There's been a lot of publicity on the Section 21, which I think everybody knows. One thing that I will say is that, you know, going forward, you're only going to have Section 8. And the impact of that is that it's going to be harder for tenants to actually get another tenancy, because now, whereas with a Section 21, they could claim you were selling the property and that was a no-fault eviction, now there's going to be a reason why they've been evicted. And so, as a landlord going forward, you want to know, well, what was on your Section 8 notice, why did you get evicted? And if they've got rent arrears, I can see it being a lot more difficult for them to get another tenancy going there. All I've got is basically what is in the Renters' Rights Bill that has gone to the House of Lords. That doesn't mean to say it's definitely going to be what will be in the final bill, because the House of Lords may well want to change some things and send it back to the Commons. So all I can do is tonight give you an idea of what's in the tunnel. When I looked down the tunnel, there wasn't an awful lot of light in there. But, you know, those of you that hang on in there, I think there is good returns to be had, because rents will invariably go up, sort of supply and demand will be there, but I think potentially the risks will be higher. A little bit like Charlie says, the scammers will come along with false documents and things like that. So one of the things there would be careful if you are doing your own referencing that you haven't been provided with documents by the tenant that actually aren't genuine.
How would you prove that, Bruce?
Very difficult.
So, for example, I'm doing the one at the minute, and I'm using a company for the reference check.
If you use a company,
They've sent a letter from the NHS saying that that's right, and it's checked against the bank statement using open banking as well, so I'm like feeling that's quite watertight.
yeah, if you're using a company, it's at the very bottom. If you're using a referencing company, then A, you've got some comeback,
Yeah.
but B, it's more likely that they will contact the employer direct or the source of the documents direct.
Yeah.
I think one of the danger areas is if you ask for bank statements and they've doctored a bank statement, changed the name on it, things like that.
With you momentarily, Bruce.
Right. Going forward, there's going to be no fixed term tenancies, which will affect particularly the students and people who want particularly for a year, or they want to have some kind of security. Where tenants have got a fixed term tenancy at the moment, the feeling is that those tenancies will be scrapped and every tenancy will go on to the new system. So even if you've got a tenancy that's fixed for the next 2 years, that won't count for anything going forward. The downside for tenants is that those that thought they had a little bit of security might find that, well, actually, the landlord, once the bill comes in, decides they want to sell the house and they don't have a choice in the matter. So every action has a reaction. One of the solutions to the fixed terms and this scenario might be granting licenses to tenants, and I've seen various bits in the press on that, but it's not an area I'm able to answer, and I think we might ask Charlie at a future meeting to actually talk a little bit about licensing on tenancies rather than just a standard tenancy. The important thing to remember is you can't sign up a tenancy more than 6 months ahead, which will in fact impact anybody who does students, who likes to do it 12 months ahead. with the grounds for possession, as I say, there's only going to be the Section 8. And what the government have slipped in is the ability to change the way Section 8s operate without having to get new legislation, which is a little bit sneaky. So if they want to change timescales and things like that, as I understand it, they would be able to do that without having to go back and get new legislation. One of the new grounds that they're going to introduce is a ground 1A, where the landlord wants to sell the property. Thing being, you can serve it 8 months from the start of the tenancy. So if it's a year tenancy or something like that, they've got at least a year in the property, but after 8 months you can give them notice that at the end of 12 months you're going to be selling it. However, those of you that think, oh, well, that's a decent get out of jail solution, if you don't sell it, I'm afraid you're not going to be able to re-let it for 12 months from the end of the notice period. So you got a tenancy, the tenants are there for 12 months, you're giving them notice, they move out because you're going to sell it, and then you decide you're not going to sell it, or things change, you're going to have that standing empty for 12 months before you can actually put a new tenant in. So, hey, oh, we're up and running, are we?
That's where Paul's option comes quite good.
Yeah. Now, there's a new ground 4A which will cover HMOs and students, which will allow you to serve a notice to get it back, because you, as you know, in the student cycle, they want to be there a year or whatever, and you want to get your students signed up for the following year. The only thing is, it won't apply to 1 or 2 bed properties. It's only 3 or more. And if you're trying to issue a ground 1 because you want to move back into the property, under the Act, it will also include you wanting to move your children in as well, or instead of yourselves. And as Charlie touched on, the ground 8, which is the arrears, the time scale is going up to 3 months. And the other thing they're slipping in, when you're doing your calculation for rent arrears, if part of that amount that's outstanding is subject to universal credit delays in payments to the tenant, you can't include that in your calculation. So where there's a problem and universal credit haven't paid the tenant their money when expected, that delay or those arrears will not be able to be used in the calculation.
But how would the landlord ever know that?
Very good question, because I was on I think people possibly know, I do get involved with a DWP focus group, and one of the issues that was discussed was, how does a landlord find out that sort of information, because DWP won't tell them. So theoretically you've got to do it through your tenant and get them to provide some sort of evidence. The problem being, if they tell you they've been sanctioned or something like that and it's not a delay, and you get to court and they suddenly produce a bit of paper that says it's down to a delay rather than being sanctioned, you know what's going to happen. Your claim's going to get thrown out.
Bruce, is there any way you can put it in a tenancy agreement that universal credit claims they would have to they can authorise you to speak on their behalf? Like, there
it's already in there in a lot of tenancies. And the answer from DWP is, sorry, we can't discuss it. And bear in mind that the tenant, there's recently been a court case whereby the court ruled that DWP could not make any deductions from the tenant's benefits without discussing it with the tenant first. Right? So if the tenant says to DWP, well, yes, I'm withholding my rent because this hasn't been done, or there's a problem, then DWP will not be able to pass that money on to the landlord. And an interesting bit of the judge's ruling was that the reasoning behind his decision was that it was wrong for DWP to withhold the money if the tenant was withholding rent because there was a dispute over repairs or something. Now that brings into the whole question, well, we have a tenancy agreement that is supposed to be legally binding. And in that tenancy agreement, it says you cannot withhold rent for repairs, etc. So, unfortunately, those of you that know me will know that I get frustrated with the legal profession. We have a set of rules, but every judge seems to interpret them differently. And it's very hard to know where it's going. But if that becomes sort of an accepted reason, then going forward, it may well be that when you try and recover rent arrears, the tenant claims that there is a repair issue and that's why they haven't paid the rent. Some judge might decide, well, oh, the tenant's right, you can't have your money.
Bruce, on universal credit, I've just done a one where I've requested direct payment, and I think if the tenant tells you they've got mental health issues or any learning difficulties, it just goes straight through.
Yeah.
So, happy days.
But the only thing that I will say is the tenant has the ability at any point going forward to change their mind. So although you think, you know, I'm getting it direct, it is potentially possible for the tenant to suddenly change their mind and want the money paid to them.
Especially at Christmas.
Yeah. Christmas or kids' birthdays, things like that. There's also going to be a requirement to give the tenant a written statement of new tenancy in simple terms. However, at this point in time, the regulations aren't particularly clear on exactly what format that's going to take. The implication for you is if you don't do it and you go to try and get possession, you will find that the legal person that they have on legal aid that's much better than your solicitor will find that as a loophole and it'll get thrown out. And it could also result in you being liable for civil penalties or rent repayment orders, because they're also increasing the scope for civil penalties and rent repayment orders against landlords.
Bruce, that written statement,
Uh-huh.
is that not just referring to existing tenancies at the point that the new regulations coming in? You've just got to give them a written statement over what the changes are within 30 days.
That wasn't the way I read it, Julie.
Right.
The way I read it was that if you were, granting-
Every tenant has to have a written tenancy.
yeah, everybody's got a tenancy agreement and it's got to be in simple English.
Yeah. I think that the written statement is referring to those that have got existing tenancies. You've got to give them a written statement, not like with what happened in Wales,
Oh.
but it's a written statement telling them what the difference is between their current one and their new one. And there'll be lots of templates that will be available for that when that comes out.
What might be easier, Julie, I don't know here, but to do a
Just
whole new tenancy.
Yeah, I would
you know, it's probably the easiest thing is once this comes in, you actually give the tenant a new tenancy which reflects meeting what you have to meet. I'm quite sure that at some point in the future, we'll be talking about it again. There's been a lot of talk about the PRS database that landlords are going to have to sign up to. What they're looking at is you'll have to register on this database, but you'll also, as a landlord, have to register with a property redress scheme, as agents currently do. Now, one of the grey areas is if a property is owned in two names, but one person actually has nothing to do with the property, and the other party, you know, looks after all the paperwork, does both the owners have to sign up to the database and the PRS, or just the person who's dealing with it?
So Bruce, are you saying the landlord will have to sign up alongside the agent
Yeah.
as well?
That's the way it's going. If you are a landlord, you will need to be signed up.
And they talked about a small charge.
There is going to be a charge, yes, for each service. I mean, currently, as an agent, probably the cheapest PRS cover or membership you can get is, I think, off the top of my head, 400 and odd quid. But whether it's going to be as much for landlords, I don't know. I've got... Julie's more optimistic than I am, I think.
Well, the thing is,
Sorry?
Is that per property or just general?
It'll be per person.
so,
So you can have some, all right.
Yeah.
The database is going to be property specific, because every property needs to be registered on there.
Is it?
Because of the documentation you've got to do. The redress scheme is landlord or property
Right.
owner.
My understanding, if you've got a company, then all directors have to be on, that's just one.
Yeah.
So if you've got properties that are in your own name and in a company name, you'll need to register.
Twice. So Julie's just clarifying here. Yeah, go on then. She knows more about this.
No. I've just had a briefing this week on this, and I was looking at the slides for the landlord database just yesterday. So with regards to the database, that is more than likely going to be property specific, because they're requiring you to upload all of the safety certification on that database. That database will give you a unique number. You'll have a unique number, and you will need that in order to market a property. They're rolling it out. They're wanting to roll it out in time for the Renters' Rights Bill coming into force. However, this is the government, and it's likely going to be through a one sign-on through the government gateway. So that's how they're looking at it. It'll be rolled out and trialled on a couple of local authorities, and then have a national rollout. So their kind of worst case scenario is that it'll be in place by the end of the year, but they're hoping to get it all done ready for then. So that one's probably... The redress scheme is per landlord, not necessarily per property.
Is that alongside with the licensing as well? Because
Yeah.
obviously we're putting everything on,
On
the
top.
licensing.
Yeah.
We're going to
Well-
duplicate the work for a different...
Well, yeah.
There was a theory that this would negate any need for local licensing.
Yeah.
All I'm going to say to you on that one is, don't hold your breath, because I can't see the councils being willing to give up the income stream because they can't afford it.
The database, local authorities obviously are going to have access to it, and there will be public access to it, so that they can just check what's available and make sure that the property meets all the requirements. It will be used more by local authorities for enforcement than anything else.
Even though they've already got us on our licensing anyway, where they don't...
Yeah.
Did you see a
No,
map?
I agree.
Does it have would it have
Pardon?
what name against the property, or is it just?
It'll
this is
probably
the
have your
property,
name and
yes, it's-
contact address.
Your name's available. Your name as the property owner is available on public record anyway, on the land reg. So
I know, but you have to pay £7 for that, and the tenant's going to do that either. So
I don't
all I'm asking is,
Yeah.
would it have a name
But
against
your name will be on the tenancy agreement anyway. If your tenant's checking it, they're going to have
No,
your
but
name.
just for rent people, like ringing us and saying, would you like to do this for you know what I mean? Like data security.
No,
Potentially.
you won't be. I don't think there's going to be contact details against the name, but as a business owner, as a property owner, whether that's a company or an individual, your name's going to be put against it. But you've got a unique. They give you a unique reference
I
number.
thought you were going to say I've got a unique name.
No. You have a unique.
Well,
they talk about the unique.
They'll Google your
reference
name and
number.
find you.
So it may be that it doesn't even have the name. It's just if it's marketed and you've got that unique reference number,
Yeah.
they can log on with that unique reference number and check that all of the certification's there. So
Right.
we'll see.
But is that not affecting our GDPR now?
No, I think that's why you get a unique reference.
Okay, so that'll be, okay.
I mean, what you will find as well is that if you haven't complied, then you're not going to be able to get possession of the property. So don't think, oh well, I'll keep my head down, I'll be all right. You know, as some landlords have done with licensing, I'll wait until I get contacted and then I'll apply for my license. It's not going to work.
What's the landlords association doing about all this? Or like,
Well, Julie, better tell you on that because
Tell you what,
I don't think they're having a lot of success.
The policy team are absolutely exhausting every avenue that they've got to try and make the Lords listen, to try and get the amendments through. That they are absolutely working every contact. I mean, me as an individual, we've had to speak to give any councils that may listen, because a lot of the councils aren't realising, so the local authorities have got to enforce all of this, and a lot of the local authorities at the housing option teams levels aren't even aware of the implications of the Renters' Rights Bill. So they're not getting any pushback, and it's a Labour government, Labour councils, they're not going to go against the party line to say this is... So that is the challenge, is because Labour have such a huge mandate, getting anybody to speak out and go against that party line is very, very difficult. And you know, and they've been in select committees, a huge amount of suppliers. So just last week, Good Lord teamed up with the Redress scheme and Deposit, TDS and Ben, all collectively did a workshop saying this is the problem, this is what's going to happen, and this is just around the fact that you can't take rent in advance, and saying this is really bad for tenants. Do you not realise this is going to exclude, you know, about 20% of applicants? It's going to exclude anybody, it's going to make people who are self-employed really hard to find tenancies, and all of this, and the extra pressure that that's going to put on. They are not listening.
yeah.
You cannot
Yeah.
make them, you can give them all the information, all the data and everything. If they're not listening, they're not listening.
Should we
But
be
they are
talking-
doing
Should we
everything
be
that they
talking
can.
to the people who are advising the government rather than government councils?
Can I
That's
just
it,
say
but
we've
we
got
just wanna wrap
absolutely stacks of slides and we're not going to get through them. I know we've all got questions, but we're kind of...
I'll, you know, as usual, I'll be here at the end, and I'm sure Julie will if you want to come. Just to sort of remind you, there is a suggestion that some of the database money might be given to councils, you know, and whether they actually need to continue their licensing schemes. Personally, I think the money won't go to the councils. They'll have to still do the enforcement, and I'll touch on that in a minute. One bit that Martin doesn't want to go forward here. It's frozen. The only little bit that I don't think really affects you is when it comes to standards, because HHSRS will include for the PRS decent home standards, and quite honestly, I think most of your properties are going to meet decent home standards anyway. And the other one is AWAB's law, which is the damp and the mould, which at the moment is applied to social properties, but that's also going to apply to the PRS. And just as an aside on that one, Newcastle Council have featured quite prominently recently as being described as a rogue council for the number of substandard properties that they have. And if you go onto our landlord platform, you'll find that there's a link in there to the article in the Chronicle covering that. One of the other things that Labour talked about was the overbidding, where landlords sort of take more than the properties advertised at. It's going to be illegal to accept any more than you actually advertise the property for. Every property will have to have a price on it. Whether that means people start inflating the price and then taking a lower amount remains to be seen. However, please bear in mind, if you are thinking about doing that, that the tenant's going to have the right to challenge any rent once they've moved in at a tribunal, sort of in the first 6 months of moving in, and it won't cost them a penny. So it's sort of the old thing, well, it's not going to cost me anything, I might as well have a go and see if I can get the rent reduced. So, where are we? Rent increases. That you're not going to be able to increase rents unless you've done it through the correct procedure, which will be the Section 13 route. You're going to have to give them 2 months' notice as opposed to 1 at the moment. And again, your tenants will be able to dispute that rent increase for free with a tribunal. And bear in mind that any increase will be frozen until the tribunal has made its decision, which currently is around about 6 weeks. I suspect after the bill, that time scale will increase. And bear in mind, it's not backdated either. So it will only come into effect when you get the decision through. And you can only increase the rent once every 12 months.
Bruce, how much can you give them 4 months notice about?
You can, yeah, there's a minimum of 2.
Say you've got 2 months to take us to tribunal.
No. Right.
What
Oh,
increase the rent to every year?
sorry?
What percent can you?
Whatever you want, Tony.
Whatever you want.
Theoretically, you've got to be able to justify that increase. As long as you can justify where you're increasing it.
Market forces, isn't it?
Yeah.
Well, it depends on what the tribunal says, because if they take you to a tribunal, you've got to be able to justify what you're saying. Whereas currently, if it goes to a tribunal, the tribunal can actually award a higher rent than you've actually applied for. But going forward, that's taken away. It will be the amount you're asking for or less. Heads they win, tails you lose.
There might have some
There's
contract
no
as
need
well.
that any savvy tenant would just take to a tribunal per se, because that means
I couldn't comment on that statement.
that means that, you know, if it took 2 months for the tribunal, it's 2 months that have to pay the extra rent.
That's right. Yeah. It's a little bit like deposits. You try and do some deductions from a deposit. There's no cost to the tenant to go to arbitration and dispute any deposits on the basis, well, I'm not going to have to pay any more, but I might get away with less. If there's no cost, then why aren't they going to do it? Important one, particularly for student landlords, you're not going to be able to accept any rent in future until the tenancy has been signed. Right? And even then, the maximum rent is going to be 1 month. You will be able to take the deposit before it's signed. So those of you who want to take the deposit, get it protected, and then get the tenancy documentation signed and include the deposit protection certificates and everything else, you will be able to do that. You will be able to sign the tenancy prior to the start date. However, you may find that if it's later or if it's only a few days before the start date and you get the tenancy signed and they haven't paid the rent, then potentially there could be the situation where you've actually got to hand over the keys even though you've had no rent. Because legally, they have a right to occupy that property from that date. The fact that they haven't paid their rent is another issue.
But that's the same as it is now, though. That's not a change. That's still...
No, but now you tend to sort of get your rent paid in advance.
Still would let them in. I know theoretically what you're saying, but it's not a change.
Well,
But if they take you to task.
Sorry, I'm going to
No,
be
sir.
the dad again.
Sorry.
right,
We're not
Okay.
gonna get home. These games to watch and
right.
it's great, isn't it?
There's another one which is the, at the moment you can, a landlord can offer the option of paying the rent up front, you know, a sizable chunk of rent, particularly with overseas students. They might pay a year's rent up front. You won't be able to take that. You can give them the choice that they can pay rent up front or take out a rent guarantee policy. Now, as I understand it, the legislation says that you have to give the tenant the choice of being able to pay the rent or take a policy. If you take away the choice of being able to pay the rent, then the fact that you can't ask for them to pay a rent guarantee policy. It seems to be a little bit of a grey area. You would be able to take out rent guarantee policy, but obviously at your expense. Guarantors, where the tenant dies, the guarantor isn't going to be liable. The only exception would be if they are part of a group, like students in a house, and there's more than one person, then they would still be responsible. But if it's for a and this is the hard bit here, if it's for a family member, so again I use the example of student tenancies, you get a parent to guarantee their child and the child dies, then under the way the legislation is shaping up, they would not be responsible for paying that rent because the government say, or Angela says, it's not fair on the grieving parent to have to pay that rent as well. That was the way she phrased it. Yeah. So, well, where there's more than one tenant, it's fine. But you've got to be careful because obviously on a student tenancy, does student A's parents guarantee all the other people? Yes, the students are joint and severally liable. I'm not convinced that if it goes to court, the judge will actually take that view over what the legislation is trying to introduce. But all I'm going to say is this is what's proposed. There's no hard and fast yet. We'll talk about it nearer the time. You're going to have your pets. Even though, yeah, if the property is unsuitable, right? If the property is unsuitable, and you advertise that, and you take the tenant without the pet, there's nothing to stop them, you know, once they've moved in, to then apply and say, I would like to have a pet. And you can't unreasonably withhold permission. The only way you get round it is if, for sake of argument, it's a leasehold property and the freeholder, in the terms of that lease, bans pets in the property. If you have another company, so you own a property in your name and you've got a company and you do a tenancy, a rent-to-rent arrangement where you rent it to your company and that then rents it out, arguably you might be able to get away with it on that. Whereas at the moment, again, you've got the facility to require the tenant to take out insurance in case of any damage. You won't be able to do that in the future. However, you will be able to take out the policy, but you will also be able to back charge them for the cost.
take a higher deposit off them if they want?
No, you're still going to be stuck with your 5 weeks,
I
Tony.
asked that today, I let the tenant in today and he says I want a cat. And I said, you can't have one. And I knew the room might be coming in.
Aye.
And he said, I said, if that's the case, I might consider asking for a higher deposit. Or in
Well-
case there's any damages.
Well, you're still limited to your 5 weeks maximum, no matter what.
Is there no differentiation Bruce, between single tenancy households and shared, where you've
No.
got shared households with individual tenancies within that? 'Cause it is unfair to say other people
Well,
in that house, it's the rights of
I'm not going to disagree with you, but
against the rights of other people maybe asthmatic and not.
well, that could be why you're saying that it's no pets. But if they go and take you to a tribunal, it depends on how that tribunal regards it. And the way the government are phrasing all the legislation, it's to ensure that a tenant doesn't have their mental well-being affected by you saying they can't have their pet. I know there is. Yeah, but that's doesn't seem to be taken into account. I'm going to try and crack on here because I'm getting Paul's telling me to hang on. Paul's telling me to shut up, but he used my time when he was prattling on with his things before.
Any question from now on, that's the deal.
Right?
You can ask questions anyone, but it's £50. They're all just like going to change anyway when they come back.
Yeah.
So, like, we've got to get through.
There's no real change.
40 slides, so.
There's no real change on the discrimination because at the moment you can't discriminate against people, if they've got kids or if they're on benefits. And that isn't going to really change. It was touched on, Julie touched on it, that councils are going to have a duty to enforce the housing law in their area, which, as many of you will know, they've got more than enough powers, but they don't use them. It's easier to just use licensing to try and sort out problems, but they're going to have to use more. And as Julie says, I don't think the councils really appreciate what's going to hit them because they haven't got the cash, they haven't got the resources to do all this, and they're not going to get any extra funding for it. The one bit that a lot of people don't realise, and I think is a big concern, is that the council will have the power to enter any rental business where without even believing that an offence has been committed, and having done so will be able to take away documents or hardware, i.e. your computers. Now, this could potentially, if it's a small letting agent, for example, you take away their computers and, sit on them for a month, are they able to run their business? I suspect it would be very difficult. And it's quite a worrying, far-reaching sort of power. And it isn't limited to companies the way it's worded. So it could be you, because you look after your own properties. As such, you're a letting business. So you get a knock on the door and they turn up and they want to have a look through. The rent repayment orders that they've got, they're going to be a little bit more far-reaching, cover new offences, and whereas at the moment, if you have rent-to-rent, whereby you're renting to somebody who is then renting it out, if the middle party doesn't comply or whatever, the liability sits with them from the tenant. In future, that liability will sit with you as the owner, and even though you may have had no rent from the middleman, you're still going to be liable. So, trying to, be helpful, brighten up the night, a few recommendations. Just make sure that your property is always ready to rent, because going forward, your tenant could well vacate unexpectedly. Make sure that your EPCs are up to date. We've already talked about C assessments coming in. Your electric safety certificates will be expiring this year. Make sure that you get those done. Don't wait until it runs out before you decide to get it done. Otherwise, I'm sure you'll find that all the Sparkies are busy, and if you want them to come quickly, then the price goes up. The other thing, and it's a simple one, if there's any repair issues, make sure you document it. Have a log for your properties, and also make sure that you do the repairs as quickly as you can, so that if the tenant leaves suddenly, you're ready to sort of rent it out straight away. And I think the important thing here is ASB or rent arrears. If it happens, then issue a Section 8 notice straight away. Don't sit and wait. Get it in early doors. Serving a notice doesn't mean you have to go to court. It means you can go to court if you need to, and you're not then having to wait further periods. And do your Section 13 procedures. If the rents in the area, market rents, are going up every year, then make sure you do a rent review every year. And we'll see you again in March for the next meeting.